Now, let me give you a couple funny stories just to kind of go hand in hand with this. Okay, first and foremost, sometimes people are kind of like, well, that's an oddly specific thing to talk about, the AIDS or HIV. Well, the reason being, let me say it again, as I said in the environmental section, science hasn't always been so sciencey. And this really clicked for me a couple of years ago when I was teaching this class, because I always thought the same thing to myself, right? I'm like, it's very oddly specific that we always bring up AIDS and HIV. And here's why. I was teaching with a fellow instructor who is considerably older than me. Okay, he's got to be in his 80s or so. And great guy, good friend of mine. And he would tell a story when we were teaching this in post-licensing together, where when he was a child and he would go visit a friend's house, his mother always gave him very specific instructions that his friend lived on the same street, just several blocks down. But his mother always gave him instructions to stop at a certain point, cross over the street to go to the other sidewalk, cross down, and then cross back over to the street. And the reason his mother was giving him those instructions was because she was trying to have him avoid a house where, you ready for this? The owner had cancer. Folks, science has not always been so sciencey. There was a period of time where people did not know what caused cancer, how you got it, how it spread. And so to that point, when AIDS and HIV had the very big epidemic in the 70s and 80s, people started getting very discriminatory towards people who had contracted it, because it was basically a death sentence at that time because of the medicine and the technology, and there was a lot of discrimination to the extent that it got very hostile. And so that's when the government amended and added, it as a consideration for the disability protection. That's why we can't disclose that one no matter what. Folks, here's the easiest way to remember it, okay? There are 3 things in this world that as real estate brokers we cannot talk about in any way, shape, or form. 3. Fight Club, Bruno, and fair housing. See what I did there? Some of you got it, some of you didn't. Fair housing is the only one that's testable, though. I apologize for nothing. Donna, don't judge me. Okay, listen, I just gotta.
No, I didn't hear the first 2 things.
You didn't.
2 things. I missed the joke. Sorry.
You did miss the joke. It was Fight Club, Bruno, and fair housing. Because we don't talk about Fight Club and we don't talk about Bruno. You're welcome. If you don't have kids, you might not have gotten the second one. Yeah, it's okay. It's okay. But fair housing always. So here's the supplemental piece, folks. The sex offenders, okay? Not a protected class. Not a material fact, but not a protected class. And so when we're dealing with sex offenders, we can share, but the best thing to do is to send them to the sex offender database. There is a database that sex offenders have to register on. There is actually a link to it in the North Carolina License Law and Commission Rulebook, so you can go and search for it. So you can voluntarily disclose and tell them. Now, I will tell you one thing that you could very well see. It's not on my test, but I've heard that it can be on the actual state licensing exam. The law that was passed that required them to be registered on the database is called Megan's Law. Megan's Law. I have heard of that showing up on the test. So if you see Megan's Law, it deals with the sex offender database. Chelsea says in Arizona, the county would mail you a notice that a sex offender had moved within your neighborhood. Does North Carolina do anything like that? I honestly don't know. Because, there's I couldn't tell you definitively if they do or don't. I would wager that they might, but I couldn't say definitively. So none of these things are material facts. Okay. You can willingly disclose the ones that don't violate fair housing if you wanted to, but they're not material facts. And so I'll tell you the other kind of funny story, like a real world story. I had some friends of mine who I went to high school with, like a girl that lived in the neighborhood behind mine. Her and her husband reached out a couple years ago for me to help them buy a house. And I found them a really cute little brick house built in like the 1970s in Andrew. And we got them under contract on it. And so I went and met them at the house, or I met her at the house that they were currently renting to pick up a due diligence check. And their house that they were renting was very close to where me and this girl grew up, like just a couple streets down. Um, and it's funny because I'll never forget it. I pulled up in the driveway and she met me outside to give me this check. And I looked at her and I said, why does this house look so familiar? Now, I knew it was close to where we grew up, but like something else about it just kind of like stood out to me. And I'll never forget it without missing a beat. This is what she said. She's like, oh, this is the house where that guy went crazy and killed his entire family and then killed himself when we were like 15 years old. I was like, oh, that's why it looks familiar. Because there was caution tape around that house for like 6 months. And it was quite an in-depth thing. And it was a big hoopla at the time. But she had kids and everything. And they'd been living there for, I don't know, years or two. And it apparently didn't bother her. And I'm like, okay, got the check. I'm going to go now. Thankfully, it's not the house they were buying. But it's just one of those things, right? So all of these are not material, okay? Stigmatized, not material, not legally required to be disclosed. Now, let me go off on a little bit of a tangent. There are 3 things that I would argue are testable in North Carolina that are always material facts. Let me just go ahead and throw them out here, okay? There are 3 things that are always, this is not a joke, this is an actual lesson, okay? There's no punchline here, this is an actual lesson. Meth houses are a material fact for life. So criminal activity, right? Somebody having a drug bust, somebody having drugs in the house, that's not material. But if it was a meth house, a little Breaking Bad action, that is a material fact for life in North Carolina because the toxic chemicals leach into the drywall, the insulation, the ductwork, and you can't get it out. So material fact or meth houses are a material fact for life in North Carolina. The next one is called synthetic stucco. Synthetic stucco. It is also sometimes referred to as EIFS. That stands for Exterior Insulated Finishing System. Exterior Insulated Finishing System. It's called synthetic stucco. And folks, if you're not familiar with stucco, it's very popular in places like Florida and coastal areas. It kind of looks like cementy. A lot of times they'll put like seashells in it and stuff like that. And synthetic stucco is not the same thing as real stucco. If you knock on real stucco, you're going to get bloody knuckles. That stuff's solid. But synthetic stucco would put like this wire over, like the siding or like the wood paneling. And then they would put this insulating board attached to it. Or actually it was the insulating board, then this wire. And then they would basically put this thin layer of synthetic stucco outside this insulating board. And it got a very bad reputation because it was so thin, it would crack. And it would allow water intrusion to get behind that insulating board. And it would cause a lot of mold and wood rot on the wood side of the house between this siding and the actual wood. And so it is a material fact for life if a home was once clad with synthetic stucco. Even if you have torn off all the synthetic stucco and replaced it with something else. Still a material fact for life that the home once had synthetic stucco. Yeah, Jack, here we go. There's the last one. Jack said, what about polybutylene pipes? Now, listen, I was about to have to spell that, but Jack did me a solid, okay? If you look in the chat box, Jack put polybutylene pipes, but be very careful. Polybutylene pipes in and of themselves is not a material fact. Polybutylene pipes, if they've ever leaked, is a material fact for life in North Carolina. They have to have leaked. The reason being, they were typically installed with copper fittings. And something about the copper fittings of that polybutylene piping, they would, minerals would leach out from the chlorine and ammonia and stuff in most people's waters, and they would cause the fittings to fail, and then they would leak. And so even if you've ripped out all the polybutylene plumbing and reinstalled new plumbing, it is a material fact for life that the home once had polybutylene pipes that leaked. Those 3 are material facts for life in North Carolina.
Their presence isn't the problem. It's the leakiness of it only.
Yeah, if they've leaked. The sheer presence of polybutylene plumbing is not a material fact per the North Carolina Real Estate Commission. However, it is an issue for insurance companies, but not a material fact in the eyes of the Real Estate Commission. So how would we know this info? You mean in the real world? Previous disclosures, asking questions, looking up permits, right? If there's a permit that's been pulled for all of the plumbing being ripped out of the house and redone, that might be a good indicator. Most people don't rip out all of their plumbing unless they've got a major reason to. Is there like a definitive database? Unfortunately, no. And so that goes back to what we reasonably should know as brokers. If you've done all your research and you can't find it, you can't be expected to know it.
Would having lead pipes in the house be a material fact as well?
It is not named as a specific category, but I would say yes, just because that is information that could affect a reasonable person's decision to buy, sell, or lease. Jack says up to mid-90s build. Yep, that's about the exact time frame. It was around that time that we started really switching towards PEX, and PEX is now the most common type of plumbing piping used in most homes, and PEX has not arguably had any issues. So about mid-90s is exactly right. Let's take this a step further, folks. Of course, we just kind of got into material facts and the different categories, but I told you the way that we get in trouble is if we misrepresent or omit these things. And so for whatever reason, the Real Estate Commission will test you on the specifics, whether or not you willfully or negligently omitted it or willfully or negligently misrepresented it. And so when we're talking about willful, folks, what does the word willful mean?
You lied.
Well,
On purpose.
say it again. Intentional, on purpose. There you go. The best thing to do when we're dealing with these types of test questions is you got to break it into pieces. Okay? Willful is intentional. It's deliberate. Negligence is you didn't do your job right, right? You should have known something, but you didn't bother researching it. You didn't verify information. You didn't do your job right. That's the negligence piece. A misrepresentation is saying something untrue. And an omission is saying nothing when you had a legal obligation to say something. Now, I'm going to warn you about the biggest mistake that students make here, right now, okay? If I said that Ashley D was a listing agent and she knew about a pending zoning change that would adversely affect the property, and I pick up the phone and I call Ashley as a buyer's agent and say, Ashley, anything I need to know about this property? And she says, nope, nothing. Of these, which would you tell me that Ashley D just committed?
Willfully omit.
And this is exactly why I'm asking this question, folks. An omission is saying nothing. Ashley said no. You cannot commit an omission if you say something. Do you see, folks, I've taught this so many times. Do you see how I'm warning you about the biggest mistakes that students make on these tests? I've seen it time and time again. That would be a willful misrepresentation. She said no. The only way it could be an omission is if she said nothing. Let me change the scenario. Ashley knows about a pending zoning change that would adversely affect the property. I never call, I never ask, she never discloses. I didn't have to call, but she had an obligation to disclose. That would be a willful omission. But when she said no, she said something. So you've got to look, there's telltale words that will kind of give you some insight. Ashley said, informed, put in the MLS, wrote, shared. All those words are going to tell you that she stated something, right? That it was a misrepresentation. Didn't say, didn't disclose, didn't, right? That's going to tell you they said nothing. The words they're going to tell you about willful: knew, was aware, was told, was informed. Negligence: didn't look, didn't verify, relied on unreliable information. So there's some kind of key triggers there. And so you're going to have to be able to differentiate these and be able to select which one is correct on the test. And I'm going to give you a few examples, but here's where I'll show you. There are several examples in the license law and commission rulebook. If you kind of scroll down here and see Willful misrepresentation gives you some examples of what they would consider willful misrepresentations. Same thing with negligent misrepresentation, willful omission, and negligent omission. So they have lots of examples to kind of study these, and they will definitely have questions about these on the test. A lot, probably not, but have some. So willful misrepresentation is when a licensee has actual knowledge of a material fact and they deliberately misinform somebody, right? Buyer, seller, tenant, landlord, doesn't matter, because we owe material facts disclosure to everybody in the club getting tipsy. It doesn't matter who you shared this information incorrectly with. So you knew and you lied. Okay, willful misrepresentation, you were a liar, liar, pants on fire. So here's an example. The agent knows, see that key word there, knows, tells you it's willful. The heat pump at a listed house does not function properly, but tells you it's misrepresentation, right? They made a statement. A customer or client, doesn't matter, that all mechanical systems are in good condition. This would be a willful misrepresentation. Let's do the next one. A negligent misrepresentation. Licensee unintentionally misinforms a customer or client, doesn't matter, concerning a material fact because the agent doesn't know or has incorrect information or made a mistake. Well, this could happen if you rely on unreliable sources. I'll give you an example of an unreliable source. The square footage on the tax records. They're not reliable. So if a listing agent shares that the house is 2,300 square feet and they pull that from the tax card and the house is actually only 2,000, that is a negligent misrepresentation. They relied on unreliable information. So if you pull it from an unreliable source, if you don't research it, if you don't verify, but you still disseminate it as truth, you are guilty of a negligent misrepresentation. So then the next one is a willful omission. Okay, there's that word willful again, intentional. Licensee yet again has actual knowledge of a material fact and an automatic obligation to disclose it, but they deliberately fail to disclose it. They elect not to. So you can only commit an omission if you say nothing. If you state anything, share anything, write anything, it cannot be an omission. Even something as simple as the word no would be a misrepresentation over an omission. So an agent knows about a zoning change, highway, or etc. that would significantly enhance or adversely affect the value, but fails to disclose it to the buyer. That would be a willful omission. They knew, but they didn't share when they had an obligation to. That'd be a willful omission.
Is there a certain time frame that this becomes willful, or like that these are, say, I didn't know, technically I was informed, but I forgot or whatever. Is there a certain time mark within the process that they can say like, oh, I forgot to disclose this material fact, but I'm disclosing it now?
I mean, arguably, if it's before they go under contract, you're probably fine. Yeah. Because no harm, no foul at that point, right? No damage has been done if they haven't written up a contract. But the sooner the better. So then a negligent omission, licensee doesn't have knowledge, but they should have had knowledge, right? They didn't research, they weren't aware, there's something they should have known, but they didn't know. And so if you are a real estate broker selling a home in Holly Springs 7 years ago, and you didn't disclose about 540 coming through the center of Holly Springs, that would be a negligent omission because you had an obligation to know this in your market. Same thing with 540 down in Southern Wake County now, I mean, and the continuation. So that'd be a negligent omission. Now, going back to forgot, like Bree said, you're not in any less trouble if it's a negligent versus a willful. You're in trouble for both. But let's say the seller tells you that their roof leaks and you forget to share that information. It's not intentionally withheld, but you forgot. A negligent omission, but you're still in trouble because you knew, you just didn't do your job right. Now, when we're dealing with these, there's a tangent I wanted to go on. Let me see if I can think about it. Something just made me think of it that I was like, I'm going to say this before I move on. What made me think of it? It'll come back to me. Just be careful, folks, because they will ask you all about these, and you've got to be able to identify whether things were negligent, willful, omissions, or misrepresentations. And I told you the best way to do this, take it piece by piece. First, figure out, was it negligent or willful? And then figure out if it was an omission or a misrepresentation. And there's those keywords in there that will help you identify it. Now, a word of caution, there is a similar concept that is not the same. And it is called puffing. Okay, puffing. Puffing, not the kind that Snoop Dogg's and his friends do, okay? It's a different kind of puffing. Puffing is an exaggeration in marketing. I know. An exaggeration in marketing. It is not going to get you in trouble as long as it really is just an exaggeration. When we say things like best view of the ocean, prettiest home on the golf course, things like that, if they are subjectively true to somebody, they're okay. But if you say prettiest view of the ocean, talking about a property at the beach, but instead of looking at the left picture, the only thing you can see from your house is that right picture, that's a misrepresentation. That's going to get you in trouble. As long as you can see it, and it's arguably true that it's the best view to somebody, you're okay. That's puffing. Folks, real estate agents love this. We never say small houses, we say cozy. We never say piece of crap, we say fixer-upper, right? Lots of potential. Right? We always give a little zhuzh in the dialect that we use to make it sound a little less. So puffing is not a problem. It's when it goes over into a misrepresentation that it becomes a problem. So if I said, listing agent submitted a listing to the MLS, property stated that you had the best view of the ocean, but you couldn't see the ocean unless you were sitting on the roof of the house. That's going to be a misrepresentation because nobody is sitting on the roof of their house in order to see the view. So that's beyond puffing. I mean, yeah, who doesn't love to stare at a good gas station, especially a low-cost fuels, right? There you go. Now, I'm going to let you read through this one. Be very careful. Kind of just apply the words that we said, folks, and see what you can come up with here, okay? This scenario, it's got a lot of information. Read it and tell me what you think. Negligent, willful, omission, misrepresentation. See what you come up with. So I'm getting some different answers between negligent and willful, and I'm even getting some different answers between misrepresentation and omission. Let's talk about it for a second, okay? A homeowner assures their broker that the 20-year-old HVAC system performs properly, yet each time the broker shows the home, the temperature is 80 degrees and the compressor is heavily rusted. Broker proceeds to tell the buyer the unit performs properly. However, after closing, the buyer determines it needs a $1,200 repair to cool the house below 80 on a warm day. The agent is guilty of. Well, the one thing we know is they said something, right? They told them that they perform properly, when obviously that is not the case. So at least we know that it is a misrepresentation. Okay, they stated something, misrepresentation. Now, some of you are saying willful, some of you are saying negligence. Folks, there is heavy indication that there may be an issue. But is it definitive at the time that the broker says it works fine? Does the broker know that it doesn't work definitively? No. Tell me where it says they know it doesn't work.
It says it when it says, yet each time the broker shows the home, the temperature is 80 degrees.
Uh-huh.
The compressor is heavily rusted.
And
That's clues,
But they
right?
only know-
that's clues, but it's not definitive.
The broker only knows what the homeowner told them, though.
Right, but common sense would say there's an issue.
So if you see me eating a salad, I'm automatically a vegetarian?
No, it means you're trying to be healthier. Well,
You can't go with indications. Let me tell you why, Brooks. Let me tell you why. I had a listing appointment 2 years ago with a family friend. It was an older lady. I'll say that. It was an older lady. And every time I visited her house, it was 90 degrees in there. Not because her HVAC didn't work. It's because old people are like lizards. They got thin skin. They like it hot in there, okay? And so I'm sitting there dying. I'm like, I got to wear the sleeveless shirt to go to a listing appointment next time at this lady's house. So there is signs, but it's not they know. They do not know. They should speculate, but that's not our job, is to speculate. They should have relayed that information. I'm telling you, you cannot put information in the question that's not there. They should have verified, and they didn't, which makes it negligence. There were things that suggested they should have followed up. They should have turned on the HVAC. They should have looked at it. They should have verified it. But they do not know that it doesn't work. They would have to know that it doesn't work in order for it to be willful. What you got, Raphael?
Yeah, in this case, wouldn't be kind of a inspection or the inspector to provide that type of information?
Sure, but yet again, that's not the question. We do have home inspections. We should always have home inspections once we get under contract on houses, and double check these things and verify these things. But yet again, I'm telling you, while you're all in the right mindset of things you should be aware of from a real estate point of view, remember your goal is to pass a test. So I'm asking about home inspectors. It's not asking about are there a good indicator. It's asking, what is this? This is a negligent misrepresentation. So we just wrapped up discussions on the willful and negligent misrepresentations and omissions of material facts, and kind of navigating those. Of course, as we said, there is some examples in that license law and commission rule book that may be a consideration for studying to help prepare. I showed you that material facts section. If I go back up, what was it, page like 13? Where that material facts law is, that is just one of the many things that if we are found guilty of doing, we are subject to disciplinary action by the commission. Of course, goes on to list, as I said, 15 different things, like making any false promise of a character likely to influence, persuade, or induce, pursuing a course of misrepresentations or making of false promises through agents, advertising, or otherwise. And I've already kind of showed you in earlier discussions how convoluted some of these things can be. And they're not very straightforward. So case in point, number 4 here says, acting for more than one party in a transaction without the knowledge of all parties for whom he or she acts. That translates to a conflict of interest and or undisclosed dual agency. It doesn't say that, but that's what it translates to. And so there are 15 of them. Now, not all of them are going to be exceptionally testable, and I'm going to show some of them in the slides, and then we'll also talk about more of them later when we formally get into the license law and commission rules section. But when I was teaching you about old car and the reasonable skill and care, I told you that was my personal favorite, but I also told you that that is equally mirrored in the license law and commission rule book. Right here under 93A-6A8. It says, being unworthy or incompetent to act as a real estate broker in a manner as to endanger the interest of the public. So in other words, if you're an idiot and you don't know what you're doing and you endanger the public, you are subject to disciplinary action by the commission. Well, that's a pretty vague rule, so let me give you an example. Using the wrong contract for the wrong type of transaction would be a prime example. In other words, a contract designed for residential resale real estate, but you used a new construction contract or vice versa. So these are some of the things that we would be subject to disciplinary action. And that's what you're going to see on these next couple of slides. This making false promises, that would get us in trouble. Promises are okay, but making promises and then not delivering on them would not be. So, and this example says an agent promises a prospect an apartment will be painted prior to occupancy and fails to have the work completed. That'd be one. Promising to buy your client something like a new fridge or something for their home to make them, the deal sweeter, but not doing it. That'd be one. So false promises will get you in trouble. Of course, these are all kind of paraphrased from what they actually are in the license law and commission rule book that I just showed you. So here's that one that I just pointed out of being unworthy or incompetent. Failure to fill in the blanks properly, failure to use the correct forms that are legally adequate for the transaction would group you into that prohibited act, subject to disciplinary action. Of course, we've also got the improper, fraudulent, or dishonest dealing, lying, not being truthful, manipulating information, taking advantage of people, self-dealing, right? Doing things looking out for our own self-interest above others. Or our clients, that'll all get us in trouble. And also, please be aware that these that I'm specifically talking about, these are North Carolina laws and rules. I mean, I'm sure there's very closely mirrored laws and rules in every state, but these are all being directly pulled from the North Carolina License Law and Commission Rule Book. Now, the next 3 slides have very similar groupings, and so I'm going to try to teach you something that will make it easier on the test. Instead of thinking of them as 3 laws, I can kind of group them together. And so let me show you what I mean here. This one says disclosure to your principal of compensation from a vendor. This one says disclosure to a party of compensation for recommending services. And this one says disclosure to a principal of compensation for brokerage services. Let me try my best to group them all together, and I'll kind of go down a couple little tangents here. In a nutshell, here's a way to think about it in North Carolina. When you are making money on behalf of your client, we tell them how much we expect to make in our agency agreements. And if we're going to make anything above and beyond what we said we're going to make, we have to disclose that to our principal in writing prior to them making or accepting an offer. Even for things outside of a transaction, if we were going to make any bonus, rebate, incentive, or anything from recommending vendors or services or anything like that, the general rule of thumb is you can accept it as a licensee so long as you disclose it to your client in writing, and so long as it does not violate RESPA. No, you don't know what RESPA is yet. RESPA is the Real Estate Settlement Procedures Act. We're going to talk about it in the financing section, but what RESPA basically states is it would be unlawful for a real estate broker to give or receive any kind of incentives, bonuses, rebates, or kickbacks from what we call settlement service providers. What do I mean? Lenders, attorneys, title insurance companies, surveyors, appraisers. We can never accept compensation from them. So if I send business to an attorney, and I use them a lot, and they try to send me a rebate for sending them business, it would be unlawful for me to take that. That is a violation of federal legislation called RESPA. And I'm going to teach you this again later. But as long as it doesn't violate RESPA, and as long as we disclose it to our clients, you can accept it. Case in point, if I have a seller, and I recommend that the seller needs to get their house painted before we put it on the market, and I've done a lot of business with the paint company I recommend to them, and the paint company says, well, hey, you sent us so much business, I'm going to give you, a $500 bonus because you sent us so much business, and this is a big job. I would have to disclose that to my clients in writing that they are offering me this rebate because I send them so much business. And as long as they're cool with it and they're aware of it, I can accept it. Because that has nothing to do with closing. Does that make sense for everybody? So the other example that you see here is a property manager. If a property manager is hiring a cleaning company to come in and clean the units, and after they clean like 10 units, they send a kickback of like $500 to the property manager, as long as the property owner is aware in writing that this is happening, doesn't violate RESPA, they can accept it. And so the same would be true of recommending, other vendors like title insurance. Well, we can't receive the bonuses for the title insurance companies, but our company having affiliated business arrangements would come into play. Alarm companies would be one, right? Alarm companies, painters, vendors. As long as it doesn't have to do with RESPA, we can accept it. And so then when we're talking about compensation for brokerage services, I got to warn you of a couple things here. It is not uncommon for new construction to offer bonuses to meet certain deadlines. So they may say something like, well, hey, we're offering you a 3% commission, but we're also offering you a $5,000 buyer agent bonus on top of it. You can accept it as long as you disclose it to your client in writing. Now understand that what I'm teaching you is the way that it's always been taught. If you were actual brokers and we were dealing with the NAR stuff, I might change my language a little bit, but I'm not going to do that for y'all because it's not going to help you in any way, shape, and form on the test. So you just have to disclose it to your client in writing of anything you're going to make in excess of your agency agreement prior to them making or accepting an offer. Here's the last big word of caution here. Nominal compensation or gifts are not something that necessarily has to be disclosed. And so the Real Estate Commission defines nominal gifts as a $25 bottle of wine or $50 gift card. Please understand, though, what I'm saying. If a seller or a vendor or a builder gives us a $25 bottle of wine or a $50 gift card, that is not something we need to disclose in writing to our clients. But do not confuse this with the LL Bean's "Did I Need a License" application, because there are zero exceptions to that. $1 would trigger the need for a license. A $5 gift card would trigger the need for a license. You see the difference? When we are talking about nominal gifts, we're saying you got a gift because of a builder or something that your client did, and you didn't have to disclose that to your clients. We're not saying that you could get away with getting a $50 gift card in exchange for brokerage and it be legal without a license. That will never be the case. So don't confuse the two. So the general way to think of it, bonuses, rebates, incentives are acceptable in North Carolina so long as you disclose them in writing to your client and so long as they are not a violation of RESPA, meaning doesn't have to deal with settlement service providers. And we will rehash that later, but that's just the easiest way to remember it for the sake of the test. Now, another commission thing that comes into play is what we call the delivery of instruments rule. The delivery of instruments rule says that all instruments, not literal instruments, folks, I'm not talking about xylophones or trombones or flutes or anything like that. We're talking about contracts, documents, listing agreements. Okay, all the instruments that we would use, they have to be delivered to the appropriate party immediately, but in no case later than 3 days. So, for example, if I have a buyer and I submit an offer for them to the listing agent, once the listing agent gets it, they have to deliver to the seller immediately, but in no case later than 3 days. If I'm a listing agent, I sign a new listing agreement with my seller, I have to deliver a copy of that to my firm immediately, but in no case later than 3 days. Just blanketed across the board, we've got this delivery of instruments rule. Immediately, but in no case later than 3 days. Now, folks, I will warn you that I have had many students in the past go into some of like the online program quizzes, and they'll come back to me and they're like, Seth, I don't understand this. What I can't, this one's throwing me off. And so like, I can't remember the context of the question, but the answer choice is something wasn't delivered within 5 days. And they kept coming back and they said, Seth, I thought it was 3 days. I thought the delivery of instruments rule was 3 days. I said, yeah, the question's asking which of these would be a violation. If they didn't deliver it until the 5th day, 5 is more than 3, that's a violation. It wasn't asking if the law stated 3 or 5. It was saying what would be a violation. So if you see that question, folks, understand delivering something in 5 days is a violation of this rule because you had to do it within 3 days. So immediately and no case later than 3 days. Last little thing before we jump back into the agency, because these have all kind of been different tangents of agency, if you will, or things that go hand in hand with it. When you're dealing with violations of your fiduciary duties, violations of license laws and commission rules, and just messing up in general, of course, the obvious thing is disciplinary action by the North Carolina Real Estate Commission. We'll talk more about this in later sections, but the best way to think about it is the Real Estate Commission giveth and the Real Estate Commission taketh away. And so they're the ones who gave you your license. If you mess up, they could revoke it. They could suspend it. They could put limitations on it. They can give you a formal reprimand. They can do all these different things to your license. Now, one thing the Real Estate Commission cannot do to North Carolina licensees, they cannot fine them. Fines is not an allowable punishment for licensees. However, we have talked about in this class already that the North Carolina Real Estate Commission does fine somebody. Who did we say they fine? That was weeks ago.
Is it the firm?
No. Firm is technically a licensee. It's just a licensed entity versus a licensed person. Time? Anybody? Nothing? Still nothing?
Timeshares.
Developers. Timeshare developers. There you go. Remember the 555 rule in timeshares. Definition of a timeshare per the North Carolina Timeshare Act: 5 or more periods over at least 5 years, 5-day rescission period on the purchase of timeshares, and fines of $500 per violation of the North Carolina Timeshare Act for timeshare developers with no maximum. So that was the one, right? This is where I plug in some of the old information so we don't forget it. There you go. Because it's only been a couple weeks and we're already, but that's okay. So real estate commission disciplinary action is the most obvious thing. Folks, if you screw up, right, you can be sued in court. By the way, not to freak you out, real estate agents are probably one of the most sued professions next to doctors. That is why you've got a firm, and that's why you have E&O insurance, but it does happen, so you can be sued. Of course, if you do something bad enough, there could be criminal prosecution. Sometimes if we guide our clients wrong, our clients could be subject to civil liability because of something we do as well. So all of these are potential pitfalls or problems for doing a real estate transaction incorrectly, but most of these would be really bad things. So here's where we're going to get into the actual agency conversations for the rest of the night, and that should set us up for some really in-depth stuff next week.